basically the language of the Montana Constitution said that there shall be no appropriations of public funds for the benefit of sectarian schools. And so the department believed that that constitutional provision required them to adopt a rule that would prohibit families who received the scholarships from using them at religious schools. And once that rule was adopted, the Institute for Justice, on behalf of 3 families, including 2 single moms, filed a lawsuit challenging that rule. And we brought 3 arguments. We said that number 1, the rule was simply illegal because a state agency can't amend legislation. That's the role of the legislature, and it was very clear that the legislature intended for families to have a free choice as to where they use their scholarships. Number 2, we said that tax credits are not appropriations of public funds. They are private dollars donated to private charities, and parents apply of their own free will, and they receive the scholarship, and they use them at the school of their choice. And at no point does the government touch the money or involved in any of those decisions. And number 3, we said if the rule is required by the Montana Constitution, then that rule and that Montana constitutional provision violates the federal Constitution because it requires the state to discriminate against religion. We said that that is unconstitutional. And so we won in the trial court on all 3 grounds. And then the Montana Supreme Court agreed that the rule itself was illegal and that the state agency couldn't amend the law. But they struck down the program under the state's Blaine Amendment. They said that because the program itself allowed families to choose religious schools, the entire program had to fall. And so we took that issue up to the U.S. Supreme Court, and last week on Tuesday, the Supreme Court issued a decision and said that no, the state cannot eliminate choices for families simply because some families are able to use those scholarships at religious schools. The Chief Justice said that individuals who want to attend religious schools and religious schools themselves are quote unquote members of our community, and that to discriminate against them is odious to our Constitution.
And so this whole thing got started because Montana had an amendment to its constitution that said taxpayer money can't be used to support sectarian schools.
Correct.
New Hampshire has a very similar amendment added in 1877. These are collectively known as Blaine Amendments after the senator from Maine back in the 1870s. Can you talk a little bit about that background? What is the Blaine Amendment? How did they wind up in all these state constitutions starting in the 1870s?
Sure. So Blaine Amendments really came to the fore in the context of school choice programs, particularly after the U.S. Supreme Court in 2002 issued a ruling called Zellman v. Simmons-Harris. And in that decision, the court said it does not violate the federal Constitution for a state to adopt a school choice program and allow families to choose religious schools, as long as those families were exercising a genuine choice and the state was completely neutral on matters of religion. But after that decision, the folks who opposed school choice said that they would continue to challenge school choice programs under state constitutional provisions. And the main attorney for the National Education Association at that time in a debate in New York said that they would continue to challenge these programs, quote, based on high and lofty principles such as separation of church and state, to Mickey Mouse provisions like single subject rules. And the high and lofty principles, the separation of church and state, the provisions that they latched onto are these state Blaine Amendments. They're found in 37 state constitutions. As you said, they derived their name from a senator in Maine, James G. Blaine, and they're all rooted in a really ugly period of American history where Americans were extraordinarily biased against Catholics. And so one of the important things to understand about this point in our nation's history is, number one, our public school system at that time was not the thoroughly secular public school system that we're all familiar with today. It was a primarily Protestant public school system. There was reading from the King James Bible, there was hymn singing, there were prayers offered by teachers, and there was specific efforts to inculcate the Christian values into the students of those schools. And also at this time in American history, we're talking about the between 1850 and 1875, there was a huge wave of Catholic immigration into this country. And when these Catholic families, these new immigrants, started enrolling their children in these Protestant schools, they found that they were very inhospitable to their faith. And so they started lobbying and establishing their own parochial schools and started lobbying the state for a share of the public school funds. And their argument was simple, is that if the Protestants were getting money for their public schools, there ought to be a system of publicly funded Catholic schools as well. But that effort resulted in a huge public backlash. And James Blaine, who had his sights on becoming president of the United States, latched on to that anti-Catholic animus, that anti-Catholic sentiment, and proposed an amendment to the US Constitution that would have prohibited states from funding sectarian schools. And that, of course, was widely recognized as Code for Catholic. And that's the US Supreme Court has recognized that numerous times. There's no doubt that that's what that meant. And even though the effort by Blaine failed at the federal level, Blaine and his allies in Congress were still able to force many states to adopt these provisions as a condition of entering the Union. And of course, there were many states that adopted them of their own accord because it was such a hot issue during that time. And that's the case in New Hampshire. New Hampshire adopted as an effort to prohibit the direct funding of a separate system of Catholic schools.
And New Hampshire's case is pretty interesting because at the time you had local school districts funding Catholic education in New Hampshire. I believe Manchester was giving taxpayer money to parochial schools because they recognized that that was educating kids and it was beneficial for the residents of Manchester. Manchester also had, there was a case. Do you remember this case, Tim? It was a Ward v. Manchester.
Ward v. Manchester, yes.
So the city during this anti-Catholic era tried to disallow property tax exemptions for Catholics, for Catholic institutions. The schools and the churches or just the churches. I can't recall exactly.
That I'm from Manchester. Makes sense that I'm from Manchester, right? That's always, yeah.
Yeah. So so there's and they lost. The city lost that case.
Yeah, basically under like an equal protection type analysis, the New Hampshire Supreme Court said, no, you can't pick and choose between religions. If you're offering these sort of tax exemptions to other religious institutions, you have to provide them equally across the board.
Yeah. So what about the argument that, look, it's public money or public funding of some sort going to religion, that's not allowed? What's the response to that argument when we're talking about this?
Yeah. I mean, it's really simple. I mean, school choice programs don't fund schools. They don't fund institutions. They provide aid to families to educate their own kids. And for the government to come in and say, no, we're going to disfavor those families who desire religious education and cut them off from state funding, that's what the U.S. Supreme Court said is unconstitutional. Justice Roberts, in his majority opinion.
All right, Tim. I mean, that's in essence telling me I have to discriminate against people.
Yeah,
against anyone in my life, and I'm not going to start now. Telling me I have to discriminate against families doesn't make any sense.
It doesn't make any sense, and we don't discriminate against religious institutions in other government benefit programs. If you're a Medicaid patient and you want to you go to a Catholic hospital or a Lutheran hospital, you can take your benefits to those institutions, and in none of those situations do we consider that aid to hospitals. We don't think of other sorts of welfare programs as aid to the institutions. We don't say that food stamps are aid to grocery stores. They're obviously aid to the individuals, and so that's what school choice programs are all about. Is just empowering families to make the best choice for their own children.
So you can take a federal Pell Grant to Catholic University.
Yep.
You can take, like you said, Medicaid or Medicare money to Catholic hospitals. And this is a similar setup where the money is going to the family, and then the family decides which institution will
In New
provide the
Hampshire, we
service.
also have scholarships. In New Hampshire, there's also a Division of Health and Human Services program that provides scholarship money right from the Division of Health and Human Services for childcare. And you can use it at any childcare that's, you know, approved in the state of New Hampshire also. And that program's existed undisrupted for years and years.
Well, the biggest childcare in New Hampshire, the largest childcare facility in the state, is a Catholic childcare center. And, yeah, in Manchester. So Kate, can you talk a little bit about, so we have a Blaine Amendment in New Hampshire, have had one since 1877, and yet the tax credit scholarship program that was created a few years ago, which your organization participates in, has always allowed parents to use that money at whatever school they choose.
Remember, it started in 2013, and originally the people did sue the state to debate that issue right off the bat. And so we did go to a lower court and debate that issue right off the bat, whether or not, and a lower court actually did say that we couldn't give money to religious schools or to families to use at religious schools. We knew they were wrong in New Hampshire. We said, we know this lower court is wrong and doesn't make any sense. And so at that time, it was appealed to the Supreme Court, and the Supreme Court did throw it out on standing, which basically said, you know, the program is fine, get out of here, which I was like, okay, bye, right? But we did have that debate here in New Hampshire already. And it was the fact, in my mind, the way the Supreme Court ruled, the Supreme Court of New Hampshire ruled, and Tim can speak more to this, but it was in line with how Supreme Courts were ruling in other states on standing and how the federal government had ruled on standing, because there had been rulings prior that already addressed all of the issues. In particular, the way our program run is people are making donations to the program, and whether you take a tax deduction or a tax credit on a donation doesn't make it the state's money. And so just that principle itself, we understood that to begin with. And so that's why we went through that process to go to the New Hampshire Supreme Court. What this Espinoza ruling does for us in New Hampshire is really enlightens us as to why we already know what we're doing is right. And I promise I won't run around the state being like, I told you so, I told you so. But in New Hampshire, our Supreme Court already knew this, and they did rule correctly, knowing that it was constitutional what we were doing. We can't discriminate against people, and we're not going to in New Hampshire. And that's the way we've always run this program.
And we followed the legislative discussion on your program and on the tax credit scholarship program, rather, in general. And it seems that every session, there are legislators who bring up the religion argument and propose bills to try to take that religious component out, right? To take out the ability for parents to go to religious schools. You've dealt with that a lot. What are you thinking? What are you hearing about the fallout from Espinoza in terms of the next legislative session?
It just took people a little while to understand discrimination, which makes sense. I mean, as a human, you don't necessarily understand those things. And so the time that I spent in the legislature discussing this from a principled standpoint is, you can't tell families that they can't go somewhere. That's discrimination. And people would be like, oh, and then they would think about it for a minute and they'd say, oh my gosh, you're right, that's religious discrimination. And so I think that this clears that up, Drew, and it should make it so that at least perhaps I don't have to repeat myself as much. I mean, I don't know. I feel like it takes a while to understand. It takes a while to understand that when you're impeding someone, that can be discrimination. You have to be careful. And so when I'm there talking to them, they'll say, well, can you make a list of all the students that go to religious schools, and can you split those out from the kids that go to non-religious schools? And I'm like, I'm not even tracking it like that. Like, we're helping families. The families are choosing any school that's approved by the DOE. I don't have them in buckets. I'm not telling them you can do this and you can't do that. The families are making the choices. And you can gladly look at a list of all 64 schools where the kids are attending in New Hampshire, and it's every type of adorable school that you can imagine, and they're doing a beautiful job. But I don't even separate them out, Drew. So in my mind, it's families making choices. We're empowering them to have freedom, and telling them they can't do something is impeding freedom. And that's it for me.
So we have, in New Hampshire, it's a tax credit scholarship. So companies give to the scholarship programs and get a state tax credit, or individuals. Important to note, if you're an individual or a business, you can donate. And I would encourage you to look into that because it's a great program. If we had education savings accounts, the same principle would apply. So those would be covered. In fact, in 2017, the Josiah Bartlett Center published a report on that with, an author who has become since well known, named Tim Keller, and Dick Comer from the Institute of Justice, and so it covers those two. But Tim, can you just really quickly talk about other school choice options? I mean, what the Supreme Court was saying here wasn't limited to just a tax credit scholarship or an education savings account. So what does it cover?
Yeah, I mean, Espinoza is actually really broad in two respects. Number one, the court said that any state that chooses to adopt a school choice program must provide families with the full array of educational options for their kids, and that they can't discriminate against them on the basis of religion. And that's a nationwide ruling. So whether a state has a Blaine Amendment or not, the state simply cannot discriminate against families because they want to enroll their child in a school that's going to comport with their personal religious values. But number two, they didn't limit that ruling just to the context of a school choice program. I mean, it really applies to any generally available government benefit program. They simply cannot discriminate against religious institutions because they're religious institutions, or individuals who want to use their benefits at a religious institution. And so this really opens the door in a state like New Hampshire on the school choice front to adopt any number of choice programs. So you've mentioned education savings accounts. So these are typically programs that allow a family to take some portion of their school funds and have it deposited into an account that the parent will control, and then the parents can design an education for their kids using any of the numbers of options that the legislature lays out. Typically with a ESA, families don't have to be enrolled in a private school. They don't have to use that money on private school tuition. They can use it to purchase materials for home education, online virtual education, paying for tutors. If the child has special needs, they can get them to speech or occupational or other therapies that might work best for them. It really puts the parent in charge to design a personalized education program for their own child. So that's now an option for families. There are things like course choice, where you can authorize families who are enrolled in public or private schools to receive a voucher, or to take their funds that would have otherwise been deposited or paid for the public school education to just purchase a course that may not be available at their high school or other school. And now those types of programs could not exclude religious private schools from the array of options. Of course, there are tax credit scholarship programs. There's just direct vouchers. It really just opens up. It gives the state legislature the freedom to design programs that will truly help parents. And I mean, I honestly don't know what the situation is like in New Hampshire with regard to COVID and school openings and all the questions that are surrounding that. I'm out here in Arizona, and it's a real hot spot. Schools may not be opening in the fall at all. Our state superintendent sent out a note yesterday saying that with the numbers the way they are, we just don't know what we're going to do. And I know that the one thing that parents are clamoring for out here in Arizona is educational options, choice, empower us to do something to make sure that our kids continue to be educated in these remarkable times of uncertainty.
But as you said, it's not just education; it's any state aid, right? So if the state, I think the term that the Chief Justice used in the opinion was subsidy. I didn't really like that term. I thought it's not, because it's not quite accurate. It's really more aid.
Right.
So that would apply to any type of aid. You can't separate out a religious institution and say, well, that type of institution can't access whatever subsidy or aid you're offering here.
Yeah, they
right,
built on
right.
Trinity Lutheran in that regard, right, Tim?
Yeah.
Correct.
In the opinion, they were basically like, if you're, Trinity Lutheran was a case where the school wanted this playground surface, and they were the top in the grant process at the state level for getting this playground surface. And then the state was like, oh no, we can't give you these wood chips or rubber, whatever they were, because you're a Christian school. And they were like, I'm sorry, what? It's wood chips, right? And so that was kind of the beginning of this discussion that, can you really not give a school wood chips because it's a Christian? I mean, that doesn't make any sense. And so the Supreme Court addressing that is really good, because it's really, it's common sense what they said, frankly.
Yeah, I mean, and Espinoza relied heavily on the Trinity Lutheran decision. I forget the number. It was over 20 times the Chief Justice cited Trinity Lutheran in this case, because it really was a very straightforward application of Trinity Lutheran in that regard. In Trinity Lutheran, the court said you can't discriminate against religion just because it's religion in an otherwise generally available benefit program. And it's the same thing when it comes to school choice. I've seen a number of opinion pieces claiming that Espinoza has somehow breached the proverbial wall of separation in church and state, or is continuing to erode it. But really, the decision, if anything, fulfills the promise of separation of church and state, because it means that the government has to be neutral with regard to religion when they're giving benefits to citizens. The government can't favor one religion over another, and it can't favor non-religion over religion. You give families, you give parents, you give an individual a choice as to how they want to use a particular government benefit, and you leave that choice in their hands.
Yeah, I think your framing of favoritism, I mean, I think that's the right way to look at it. And that's certainly the way the court presented it is,
yes.
If you have an aid program, a relief program, subsidies, however you want to define it, a government benefit that is equally available to all citizens or all organizations in the state, that's okay. It has to be equally accessible to all. Once you slice some groups off and say you cannot partake of this benefit, then that's where you run into problems. So it's not a violation of the separation of church and state, because the states would not be allowed to say, we will support Catholic schools and only Catholic schools. We will support Lutheran schools or Protestant schools. We will establish some sort of official church or officially sanctioned religious organization, and that group will get favoritism. That's also not allowed. It has to be equal access to everybody. And I think that's the really important thing here, is that you can't exclude people based on their faith. And I think that's really where we had gotten, is that these programs were saying, well, if you partake in these programs and you express no faith and you don't pursue that as through these programs, then that's okay. But as soon as you do that in a sort of faith-based way, that's not okay. So that was the court ruled that's discrimination against.
Yeah, the neutrality is the principle, Drew. Yes, being neutral is the entire principle of the discussion. That's why I'm saying it's common sense.
Yeah.
Because we all know we have to be neutral. And that's it.
So we have, and I don't want to get too much into this, but we have a question about just the Croydon tuitioning program. And so in New Hampshire, we have a law that says if there's not a public high school in your community, then your local school district can tuition kids to a high school if you don't offer that one through the public schools, right? So it's high school or whatever. In Croydon, they're doing this. How would this ruling affect tuition programs, or would it?
So it does affect tuition programs. There's no doubt in my mind. New Hampshire is not the only state in the Northeast that has these types of programs. They also exist in Maine and Vermont. And in all three states, as I understand the programs, they currently prohibit families from using their tuition benefit to attend religious schools. So this exclusion of sectarian schools from those programs is unconstitutional under the Espinoza decision, and it must either be struck down by a court, or the state legislature should take action to amend those statutes so that families can make a free and independent choice of which schools are going to work for their kids.
Yeah, so that would be something for the legislature to take up next session, is to look at that and address that in light of the Espinoza ruling. Well, I think we're about out of time. That's
It's like drinking from a fire hose. That was fast. It's a lot of information in a short period of time.
yeah, I think we got the questions answered. So thank you everybody for participating. We really appreciate it. And thank you so much to our panelists, Kate Baker and Tim Keller. You can find the Josiah Bartlett Center. We have a paper on this from 2017 on this issue, but we have lots of info on educational choice, tax credits, all kinds of public policy in New Hampshire at jbartlett.org. You can go there. We have a weekly newsletter that you can sign up for, and I would highly encourage you to do that. It's really a good source of information about public policy in New Hampshire. Kate has the Children's Scholarship Fund. Where can they find you, Kate?
csfnewhampshire.org and all the tax credit information there. And we're still accepting applications from families. So that's on our apply page also. And so happy to hear from anyone.
Yeah, Kate's program is great. It just, for those of you who might have come in late and not gotten it, Children's Scholarship Fund, you can donate to the scholarship fund and get a state tax credit for helping kids go to a school where they find that they're getting the education they need. And Tim Keller from the Institute for Justice, where can people find you?
You can find us at www.ij.org.
All right. Well, thank you so much, everyone. And we look forward to the next time we can do this.
Thanks. Great seeing both of you.
Great
Yeah,
seeing
same to you.
you. Thanks for your work.
Bye.
Right.
Bye.
Bye.